Welcome to Legal Lines. My name is Tom O'Shea, the host of the show, and today our topic is employment law, and my guest is Michael King, an attorney with Stock and Leader, who emphasizes his practice in the area of employment law. Welcome, Mike.
Hi, Tom.
And let's just start off with a very basic concept that I hear. I practice no employment law, but I know enough to say to people that in Pennsylvania, most employees are employees at will. Now, what does that mean?
Certainly. It is true. Pennsylvania is among a minority of states that have continued to recognize in general the employment at will doctrine, it's called. And that stated most simply means that there is no stated term of employment and no agreed upon term of employment. And essentially it means that either party, either the employer or the employee, is free to terminate the relationship at any time, sometimes stated at any time, for any reason, or for no reason. And that is the classic statement of it. It's not quite true because there are any number of statutory provisions in the law that are exceptions to the at-will employment doctrine, and most all of us are familiar with those. And they include all of the classic discrimination statutes. So we know that it is illegal, for example, for an employer to discriminate against an employee because the employee is a minority, is black or Hispanic or Asian or whatever. We know that it's illegal for employers to discriminate on the basis of gender. We know that it is illegal in certain circumstances for an employer to discriminate on the basis of disability. Or religion or ethnic origin and so forth. So there are all of these exceptions. So the real rule probably should be an employee at will can be terminated, or the relationship can be terminated at any time for any reason or for no reason, except for all of these reasons that Congress and the Pennsylvania legislature have said are illegal reasons.
So it's fair to say that you're an employee at will, but you cannot be terminated for, let's say, an illegal reason.
Exactly, exactly.
And if somebody is terminated and they believe that the reason was illegal, is the burden of proof on the employee or the employer to establish whether or not it was an illegal reason?
Typically under the discrimination statutes, the federal laws as well as the state laws, the burden is always going to be on the plaintiff to prove discrimination. Employers are not technically required to prove that they did not discriminate, but as a practical matter in the give and take of a trial setting, it's really a little of each, and that is the employer initially has the burden of establishing that he or she is a member of the protected class, that something bad happened to them in the employment setting. They were fired, they were not hired, they were demoted, they were suspended, something negative happened to them. And then the third element of what's called the prima facie case is that they have presented some evidence to link the fact of their being in a protected class with this bad thing that happened to them. So the classic would be, I'm a minority, I was fired for absenteeism, I'm black, but in fact there were white employees who had worse attendance than I had that were not fired. Therefore, the assertion would be that I was not really fired for absenteeism, I was fired because I was black. And so the employee sort of articulates all that, what's called the prima facie, or at first blush, the case, and then the employer has a responsibility under the case law to step forward and say, no, those are not the facts. In fact, employees with attendance records like yours, whatever their color, whatever their nationality, and so forth, the company dealt consistently with, and so forth.
So it goes back and forth, and sometimes it sounds like each case is going to be decided on the individual merits of that case.
Absolutely, and it is sort of a ping-pong procedure. And again, the U.S. Supreme Court really made these ground rules, a number of years ago, in a case called McDonnell Douglas. And the reason that a specific kind of procedure needed to be developed is because of the inherent difficulty of proving discrimination. If you think about it, an employee trying to prove that an employer discriminated against him or her is essentially trying to prove what was going on in someone's head. It's unlike an accident case where we bring in an accident reconstruction expert who says the red car was going 75 miles an hour and blah blah blah. In discrimination cases and in discrimination law, the ultimate question is what was someone thinking when they made a decision, typically to terminate someone's employment. And because of that, the evidence is almost always circumstantial. There's rarely a memo that says, fire Charlie, he's too old. Nobody
Well, if we talk
does
about
those memos.
employment discrimination, and right now with many companies downsizing, typically an older employee would have seniority. An older employee might be getting paid more for his or her time than a younger employee because of the seniority they've built up. Might have greater benefits, more weeks of vacation, more sick leave, whatever. And it would be a greater savings for the company to terminate the older employee than the younger employee. So if there's an employment at will, technically the employer can come in and say, we're letting you go, we don't need you anymore. And if the older employee could say, yes, but there were 5 people who were let go, they were all over 55, and all the people under 35 were retained even though they have less experience, it sounds to me as though the employee may be able to prove age discrimination.
Possibly. Keep in mind that in a non-union setting, there is no obligation on the strict obligation on the part of the employer to lay off by seniority. Many employers choose to do that, so that typically you would see a last hired, first laid off kind of setting, and that is most union contracts have language in that would require the employer to do that. But many employers, certainly in York County, are non-union and do not have that obligation, and they have some more flexibility in deciding who to lay off. But again, it would not be unusual if an employer is doing a reduction in force. Part of the thing that the employer's counsel would do would be to review, who is being laid off, and to what extent are those people in protected classes, whether it be age or gender, females, or national origin, or
Is there an
colors
age
and
for
so forth.
protected class?
There is.
What is that age?
Well, in the federal and the state law, it's 40.
Oh, that
And
sounds so young now.
It does, but there are also, if you look at the York City Human Relations Ordinance, it defines age as as persons that are protected as anyone 18 or older. So in theory, and every once in a while this happens, you could actually get a claim if for a city employer where someone says, I was 21 and I was discriminated against because of my age. Sounds rather absurd, actually is rather absurd, but it's simply a quirk of the York City ordinance. Some other ordinances may do things like that. But back to our reduction in force setting, the fact that there's not a union contract obligation to lay off by seniority generally does not result in employers laying off the more experienced, more highly paid employees, because that's usually not a good strategy, and it does risk discrimination claims.
You bring up the fact that there's a different standard for union employees. Is there a different standard?
Yeah, I mean, back to the employment at will context, and that is most union contracts, whether we're talking in the private sector or the public sector, would have what are generally referred to as just cause provisions. And in the public sector, there's even case law that implies a just cause provision in a public sector contract. And that essentially means language that either says or is implied to say the employer may not discipline, discharge, suspend, demote, and so forth an employee without, quote, just cause. So that automatically takes that person out of the context of employment at will and essentially gives them a form of job security. And in the particular situation with the union contract, the way those rights are enforced is not through the court system, but through arbitration, through grievance arbitration. So an employee who is maybe terminated in a union contract setting would typically, or the union would file a grievance on behalf of that person saying he or she was not fired for just cause, and at the end of the day, an arbitrator, hopefully a neutral arbitrator, would make a decision that says this employee was discharged for just cause or was not discharged for just cause. And if the arbitrator says it was not discharged for just cause, the arbitrator would have the power to reinstate the employee with or without back pay.
So it sounds to me as though the union bargaining agreement, which is technically a contract between the members of the union and the employer, has basically contractual provisions that override the Pennsylvania law, which would be employment at will.
Absolutely, and the same is true of private contracts, and again, particularly, for example, at executive levels, but not necessarily, but any level of employee, if he or she has the leverage and the ability to do that, can enter into an employment contract with his employer and gain certain job security. So the contract could say, Mr. Employer agrees to employ the employee for a period of 5 years, subject to termination for certain reasons or cause, or not showing up or not doing the job. So individuals can, if they have the leverage and essentially the power to do that, can negotiate their own employment contract, which also takes it out of employment at will.
So you're talking about the leverage and the power to do that. The average employee typically does not have that leverage and power.
The average employee does not.
But technically, an employee could say to the employer, I am only going to work for you if I have a signed contract that specifies how long I will work here, under what circumstances I may be terminated, under what circumstances I may choose to leave.
Absolutely.
And it's legally binding and has to be enforced, and I'm no longer an employee at will.
Absolutely. And you find that with employees who have special skills, whether they be technical or sales or artistic. We know it happens in the sports arena.
Right. Yeah.
And if you're a talented athlete, you absolutely have leverage to talk about what the terms of that employment
But
might be.
in most cases where people don't qualify to get that type of arrangement with their employer, a union may do that for a whole group of people who perform a certain job function and have a contract that the employer must follow.
Exactly.
And in most of these contracts provide that if there's any enforcement mechanism, it would be through some type of arbitration system rather than going through a trial in front of a court with a jury or something along those lines.
Exactly. So and again, you'll see that in both the public and the private sector, that collective bargaining agreement, union contract provisions are enforced typically through arbitration. But again, all of those employees would also, if they felt they were the victims of discrimination, would also have court remedies through the statutory process.
Mike, I'm going to cut you off here because our time is almost up, and we will be back, though, after these breaks. Welcome back to Legal Lines. My name is Tom O'Shea, the host of the show, and today's topic is employment law, and my guest is Mike King, an attorney with the law firm of Stock and Leader, who specializes in employment law. And we were talking about the statutory exceptions to employment at will. And you also told me during the break that there are also public policy exceptions to employment at will.
Right.
Could you explain that?
Certainly. This is kind of how in Pennsylvania, I guess, to the extent that we have a case law embodying the concept of wrongful discharge or unjust dismissal, it arises out of a very, very limited number of cases that involve what we call the public policy exception. An actual case that would illustrate that would be an employer who terminated an employee because the employee was absent from work because he had been called to jury duty. So again, you connect those dots and think we have a civil justice system, criminal and civil justice system, that relies upon citizens to answer the call and to come forward to serve as jurors when so noticed. So,
and quite frankly, the employee had no choice but to show up for jury duty.
Exactly. So again, you look at that from a societal point of view. The society cannot tolerate employers terminating someone's employment because they serve jury duty. So that would be the public policy exception. So back to our conversation about at-will employment. Cross that one off the list. The employer, can terminate the employment for any reason or no reason, but not that reason, because the legislature has said we want this system with jurors serving, and we can't tolerate employers who behave in that fashion. Another classic example that I use in seminars when I'm talking about this issue would be, suppose an employee works in a factory near the Susquehanna River, and a couple of times a day his job is to open a valve and release toxic waste into the Susquehanna River. And either the federal EPA or the state DEP people learn of this and want to investigate, and the employer says to that employee, I don't want you to tell them what you do. And those investigators come in, and the employee's under oath and ask, Mr. Jones, I understand that twice a day you open this valve and release toxic waste into the Susquehanna River. Is that true? And the employee truthfully says, yes, that's true, and then later gets fired. Well, again, I say to my employers and my human resource people, if you need me to tell you that that's wrong and that you're going to get in trouble for doing that, you need to go back to square one here, because you are hopelessly out of touch with reality. So we can't have a society that wants to have cleaner rather than not so clean streams, and then allow employers again to behave in that way. The thing that employees sometimes do is they think they have an issue that they think is important, that they try to turn into, quote, a public policy exception. And many cases where employees have alleged that they were terminated in violation of some public policy, most of those cases fail. And the courts ultimately determine if this is not something that the legislature has said is a big deal, it's not a big deal. And the fact that this employee thinks it's a big deal doesn't make it a public policy issue. So it is a very, very narrow exception.
And the burden of proof would also be on the employee who's terminated.
Would be, and there is not that shifting, going back and forth situation that you have in classic discrimination law.
Okay. But we also mentioned before the break the concept of employment at will applies generally in the private sector unless there's a contract, whether it's an individual contract or a union contract with the employer. But that the concept of employment at will may not apply to all public sector employees.
That's certainly true, and it's much more common in the public sector for there to be some form of job security. The classic example of that would be tenure for public school teachers. The Public School Code in Pennsylvania, Public School Code of 1949. Unfortunately, we're still operating under the Public School Code of 1949.
That's been worked for 60 years.
Yes, well, some would take exception to that, but and obviously it's been amended. But the concept of tenure has been around for many, many years, and that is a statutory form of job protection for teachers and other professional employees in the school setting. There are also provisions in the school code that essentially protect other employees, non-teaching employees, from what we would call cause dismissals. So if an employee, if a school district, for example, is laying off janitors or cafeteria workers because they're not needed anymore, they're pretty much free to do that. If they are terminating a janitor or cafeteria employee because of poor performance, then that employee doesn't have complete job security, but does have a right to a hearing before the school board if he or she wants that. So the right to have a hearing is again effectively an exception to the employment at will doctrine, because the employer cannot say, I, the employer, think you're doing a lousy job, we'll see you later. The employee does have some recourse in that setting, and so it's not unusual in the public sector to see that kind of
And that does not
protection.
just mean at the school setting. That would be government employees at basically any level?
At a lot of different levels. And again, the school setting is probably the one where there are the most protections. But again, we have, if you look across municipalities in Pennsylvania, certainly police and fire employees, and again, we're back into the union setting, but even without the union setting, there are certain civil service protections for those types of employees.
That's what I was wondering, because when you mention teachers or police officers or firefighters, I'm thinking most of those groups do have some type of union.
They do.
But the public sector, there are public sector employees who may not be in a union, and they still have certain protections.
Not all, but a good number of them have some. Again, when we say protections, it effectively is sort of a right to due process. You know, the Due Process Clause of the Constitution says the government may not deprive a citizen of property rights without due process of law. Due process of law, as you know, basically means notice and an opportunity to be heard,
So is
a
that,
right for a hearing.
has that been interpreted that the job is a property right, or is it the right of property or income? Or
Again, in an employment at will setting, an employee has no property right in their employment. But, for example, back in our school example, where the school code creates tenure, that creates a property right in employment. And again, the fact of public employment invokes the Constitution and all sorts of other things. So, for example, in the private sector, there is no right of free speech. You know, and occasionally, I'll get a call from an employee who maybe has told his employer what he thinks of him, and thinks that he's doing that in the exercise of his right of free speech. Well, there is no right of free speech in that private sector context. The right of free speech has to do with prohibiting the government from limiting the right of free speech, not a private sector employer. And similarly, in public employment, we have search and seizure issues that you wouldn't have in private employment. If you work for me in the private setting, you don't have any protection.
so you could look through my desk, for example.
I can look through anything anytime I want to, but if I'm a public employer, then now I'm the government, and now I'm subject to the Constitution, and now I'm subject to the the Bill of Rights, effectively, the amendments, and now I have to be more careful. That doesn't mean that a public employee gets to tell his or her supervisor necessarily what he thinks without any repercussions. But in the private sector, there's no issue at all. In the public sector, we have to stop and think, does this person have a right of free speech in this context, or is this just an employee who's mouthing off who I get to fire anyway?
Okay, let's talk briefly about a severance agreement. We have we're seeing quite a few of them these days, where a company lays off several people and they offer them a severance package. Now, typically the company will ask the employees to sign some type of agreement when they get the severance package.
Right. In our country, unlike a lot of the European countries, severance pay is legislated. So that if I'm a German company and I'm laying off a number of employees, I would very typically have a statutory obligation to provide a certain amount of severance pay and do that. We don't have that in this country. There is no right to severance pay, again, unless the employee, through a union contract or through an individual contract, has negotiated, if something bad happens to me, here is my deal. And again, some employees have those agreements in place, most do not. So there is no right to severance pay in Pennsylvania and in the United States generally. But employers typically, unless the company is simply failing and falling off the table, they typically do offer severance on the basis that the employee needs some assistance in this transition to some other new job, and the company is in a better position to finance that than the employee is. So there's kind of a social welfare sort of approach to that employers take, that it's the right thing to do, and this employee has been a loyal employee for a number of years. We're not firing this employee because he is incompetent or is not performing the job or doesn't show up. It is the economic conditions, and employers feel an obligation in that setting. But since it's not legally required, while they're doing that, they would almost always insist on a release of claims, because what the employer doesn't want is to write a big check to the employee and have that employee take that check to his or her lawyer and then have that lawyer make trouble for the employer when the employer had no obligation to provide the money at all. So it's very much a quid pro quo. Here is some money or pay over the next 10 weeks or whatever. I will continue your health benefits for X period of time. In exchange for that, I want a promise from you that you're not going to make trouble for me as the employer.
So you won't come after me saying it was age discrimination
Exactly.
or some other public policy problem that I violated as the employer.
Exactly, exactly.
And one thing that I've learned recently is that someone who is receiving severance pay over a period of several weeks or months is still eligible to receive unemployment compensation benefits while they are getting the severance pay.
That's true in Pennsylvania. It's not necessarily true in some other states, but it's true in Pennsylvania so long as the severance payments are clearly delineated as severance payments. So an employee in that situation, and usually it is the employer's intention that the employee also get the unemployment comp benefits, that it is important that the payments be designated as severance. And so as long as that is designated in that way, it does not interfere with the employee's ability to draw unemployment.
Okay. Well, thank you, Mike. We're almost out of time here. I would like to thank you for coming on Legal Lines. My guest today was Michael King, an attorney with Stock and Leader. Our subject was employment law. And I would like to mention that our program is brought to you by the York County Bar Foundation. And thank you, and I hope you come watch us again.